things and grab a little bit of lunch. Sometimes we're a little late getting to these, so we apologize for that. This is a continuation of the Public Safety Committee meeting from last week where we were looking at an ordinance amending Chapter 46, dealing with body cameras in particular. We are also going to tack on another issue today that was on our agenda today, dealing with no-knock warrants, that is sponsored by Mr. Penn. So in starting the meeting today, we have all of the committee members here, as well as all of the council members, members of the clerk staff, a few members of the administration. I suspect more will come, and members of the public. I see one reporter. Wow, Dale, you're it, huh? Okay.
Brendan's still eating over here.
See, I told y'all, everybody's still eating. So we have an amendment that was on our table when we got here, dealing with body cameras, and then we'll take up the no-knock after that. Michael, if you can go through the body cam amendment, just to explain to everybody what it says and where we are on the body cam ordinance to date.
Thank you, Chairwoman Gregory. Based on last week's meeting, I have circulated a draft, which is now before everyone, of the so-called body cam ordinance. The major change to this is that it adds a subsection C, which provides for a 7-day waiting period between any use of force incident involving these recordings, body cams, dash cams where applicable, and self-reporting by the City of Mobile to the Mobile County District Attorney. This is basically to attempt to give so-called stakeholders a chance to have an opportunity to request this footage before it would be potentially subject to grand jury secrecy. Now, we of course have no control over what the district attorney's office does. If they request it 30 seconds after an incident, presumably it would then still fall within grand jury secrecy. And we can talk about the time period. I believe Councilmember Daves had an amendment he would like, which I think makes it a little bit tighter. But that's in substance what it does, is puts a 7-day waiting period there before self-submission by the city to the district attorney. That would not operate as to any submissions to the Department of Justice or the state or federal authorities.
Yeah, one more time on the subsection C there, Michael.
And maybe it'll help if I just read it out. There shall be a 7-day waiting period between any use of force incident involving law enforcement recordings and any self-reporting by the City of Mobile of same to the Mobile County District Attorney for use in grand jury proceedings. This waiting period is expressly to enable any person within the meaning of Alabama Code Section 36-21-212, subsection C, subsections 1 through 6. Those are the people that we've been calling stakeholders, to promptly request disclosure of recordings prior to application of the Grand Jury Secrecy Act. This provision shall not apply to delay any active criminal investigation or any other submissions to the state of Alabama or federal authorities. By the way, I'll just go ahead and say what Councilmember Dave's proposal is just to sort of add into there, instead of that last sentence, it'll read, the 7-day waiting period shall not apply to delay any active Mobile Police Department criminal investigation or any other submissions to the state of Alabama or federal authorities. Just make it clear that if there is an active city criminal investigation going on, this will not apply to delay it.
Madam Chairman.
Yes, Mr. Daves.
Actually, what I had suggested was that last sentence of subsection C read, the 7-day waiting period shall not apply to any active MPD criminal investigation or any other submissions to the state of Alabama or federal authorities. In other words, the way I read it is that the first part of subsection C applies the 7-day waiting period only to submissions to the Mobile County District Attorney's Office, which would kick in the Grand Jury Secrecy Act. other investigations, in other words, the 7-day waiting period would not apply to other investigations, investigations by the Mobile Police Department or by an instrumentality of the state or federal government. Now the question may be, why not? Because I think that we need to give the police department an opportunity to assess the situation and determine whether to assess the situation, make a determination as to whether the body cam footage should be forwarded on to the district attorney or the FBI or anybody else they want to forward it on to. That's my opinion.
All right, William?
Is that on a singular? Is that on the singular event that just happened, or are you talking about on parallel investigations, Mr. Davis? Well, are you asking to the event, the incident that happens that we're asking the 7 days on in the timeline? Or we're saying that we should not prevent the police from doing any other investigations on that event, or we should not interrupt other investigations that are going on?
Maybe both.
Because if I'm hearing that right, it sounds like if the police have an investigation and it's going to affect it, then we should immediately self-report. And the intent of this is to give the stakeholders a chance to see it. So if you stick that in there, sounds like a subclause to say, let's go ahead and self-report immediately, which then prevents the 7 days. That's what it sounds like.
Well,
Am I misunderstanding that?
I'm
Mr. Linder?
I'm not sure you are. I think before the body camera footage is released to the family or to the individual themselves, you have to give the police department an opportunity to make a determination as to whether they believe there has been a possible or probable criminal conduct that needs further investigation. Because if you don't, you're going to impair everything. You're going to impair the quality of the investigation.
I don't want to see anything that's going to prevent the investigation or hinder the investigation, but we need to make sure that we give the stakeholders an opportunity to see the body cam when these instances happen, and we don't need to put a stumbling block in a way to prevent that. I don't believe the administration was at odds with the original request here, and I'm hoping that the council's not either. I mean, we need to be in a position to where, like I said last week, that we are transparent and we're upholding the public trust. And to stick a sentence in there again makes it seem like we're trying to hide something. And in no case at all is the police department trying to hide anything, I would hope. So, I say leave it as is if we're trying to add something that may stumble the process.
Michael?
Well, I think the intent behind this section was just to clarify that in the situation, like I would say sort of like the Joan Dallas situation, where there were not criminal charges immediately or criminal investigation immediately contemplated out of the incident, but there was a death shortly after somebody had an altercation, and the city then went ahead and self-reported the incident to the DA and to the Department of Justice. This would address that situation where there isn't otherwise a criminal investigation going on, and those files should remain confidential during the pendency of an investigation, and generally do. And then when requests are made for footage or police materials like that, they generally cite the investigatory privilege. So that's what this is meant to preserve, is that if there truly is a criminal investigation going on, it is not hampered. But at the same time, this is meant to address the situation where where the city, by its existing policy, was self-reporting to the DA. There would be a block of time for the stakeholders to request that in between the incident and then self-reporting to the grand jury or the DA.
So the stakeholders still have the opportunity to see the footage within this block of time.
If it's a situation like that where there isn't a criminal investigation ongoing.
The whole point here is to give families an opportunity to review, not take it, an opportunity. And what that language does is it negates that whole section if we add that for a situation like Jawan Dallas again. It takes that away. I don't think that's where we want to go.
Well, if the intention is to allow, let's just call it family for ease of, or what's the legal term for these? The stakeholders. If the intention is to allow the stakeholders under any and all conditions, no matter what, to see the footage within the first 7 days after it is taken, then I don't know why we're going through all this anyway. It'd be much easier just to say that. In which case, I would be opposed.
I think the language says exactly that in subsection C as written. You're asking to change that.
No, what the language says in subsection C is there's a 7-day, even before I did anything to it.
Right.
There's a 7-day waiting period for before it can be turned over to the district attorney. Before it can be turned over to the district attorney. And then it goes on to say, this provision shall not apply, in other words, the 7-day waiting period, shall not apply to delay any active criminal investigation, which in my mind includes the MPD, or any other submissions to the state of Alabama or federal authority. So what that means to me is that if an incident occurred and the MPD immediately decided that an investigation was in order, then the 7-day period, the stakeholders would not be able to view the footage.
Well, you're saying that MPD controls that. But again, the whole point in avoiding the situation of non-transparency and public trust, again, you're taking that away in an incident like this. If we add that language, it makes the whole paragraph mute. It says yes in one end and no on the back end. I don't see that.
Right.
I'm not understanding that.
No, let me finish.
Oh, go ahead.
Again, if the wish is to make the footage available to the stakeholders under any and all circumstances in the first 7 days after the incident, the easiest thing to do is just to say that. But that's not exactly how this is worded.
State law that's in place as well.
Right.
Madam Vice,
Yes, sir. Go ahead, Mr. Penn.
thank you, Madam Vice President. I know in the situation, the family of the 16-year-old was able to view the footage a day after. With the language in this, in section 1C, would this allow the family to be able to view the footage?
In my opinion, it would and did, or rather, when everybody it would. Again, this is meant to preserve basic law enforcement investigatory privileges, which again is a police investigation file. And Chief Barber wants to step on this, please do. But a police investigatory file, when criminal charges are being investigated for possible bringing, is highly confidential, is protected from discovery and lawsuits and so on and so forth. That's to stop people, basically, let's say criminal charges are brought against me and I go to court immediately and bring a civil lawsuit and try to get the police investigatory file. That's meant to stop situations like that. This is a pretty broad standing precedent within U.S. law. In the case of the 16-year-old, again, I think the administration can probably speak to the facts of that better than I can, but I don't believe, certainly against the 16-year-old, no criminal charges were contemplated. It wasn't something that there was an ongoing police investigation going on. And so at that point, the city had not self-reported it yet. And so the family, there was no legal barrier to the family coming in and requesting to see the footage, which they were allowed to do. I think this would preserve that in those instances. But again, where, say, the subject of the footage actually has a criminal investigation going on against them or something of that nature, I think in that, then what this extra language does is make sure that the law enforcement file remains confidential and non-discoverable and non-disclosable until the investigation is concluded and either charges are brought or not brought, at which point then it would be subject to disclosure.
One thing that kind of struck me on this is in some respects, it sounds like we might be trying to beat the clock. And I don't think that is the intent. I don't know how long it takes the police department or the DA to determine if it is going to be an ongoing investigation, if charges are going to be brought, or any of those types of things. Could take one day, because a DA is usually on site during these incidents, but it could take longer. So I thought that giving the 7 days was like the minimum or the maximum, the maximum amount of time that this sort of thing could be going on prior to allowing stakeholders to see, because we don't want to interfere with an investigation, but we don't want to drag our feet with an investigation and determining whether it goes to a grand jury and all those kinds of things, because the stakeholders do need the opportunity. But again, we don't need to play beat the clock. So what am I not understanding?
Well,
Michael?
Well, again, on the intent on this one is, and again, let me read the first sentence of it back. There shall be a 7-day waiting period between any use of force incident involving law enforcement recordings and any self-reporting, emphasis on self-reporting, by the city of Mobile of same to the Mobile County District Attorney for use in grand jury proceedings. So this is the attempt, or the intent here is to try to give stakeholders a window of time where, at least by the actions of the city, we haven't shut the door on them as far as the Grand Jury Secrecy Act goes.
As far as the Grand Jury Secrecy Act goes.
Correct. That is what C is meant to address, is the Grand Jury Secrecy Act, but leave things at status quo as far as organized criminal investigations, things of that nature.
Does it have to be shall be 7 days, or could be up to 7 days? I don't know. Yeah, I know y'all have been working on this and trying to find some common ground.
Yeah,
Joel?
As far as the 16-year-old situation was concerned, the police department obviously made the determination rather quickly that a criminal investigation was not called for, and therefore offered to let the stakeholders view the body cam footage. And certainly what I'm suggesting is not different than what Mr. Linder has suggested, which is in a situation where there was an incident and the police department made a decision that there was not appropriate for it to be further investigated, then they would go ahead and give the stakeholders an opportunity to view the footage.
Okay, William?
yeah, but that one sentence gives the police department a chance to block the viewing immediately based on what they think. It gives them the opportunity. From the way I see it, it immediately gives the PD the chance to say, no, we have an investigation now, you can't see it. And that's what we're trying to avoid at this point in time. We're trying to allow the stakeholders an opportunity. And if the police with that one sentence can say, no, it's under investigation, then we've taken it away anyway.
Ben, did you have something before Jimmy? Okay.
I got something for Chief. How long does it take to decide if an investigation would be necessary?
Well, some of that is almost immediate, right? Whenever there's an allegation of criminal complaint, then there's an investigation launched immediately to gather evidence and pursue it. The portion of this document that you're referring to that gives the police department discretion under a criminal investigation, active criminal investigations, is actually in B. It's not in C. The way I read C on Joel Dave's amendment is that we may continue to interview witnesses, we may continue to pull video evidence from store surveillance or ring camera, whatever we're doing, to continue our criminal investigation while we go through the 7-day waiting period. Now,
But that wouldn't defer or block the stakeholder from seeing the body cam is what I'm hearing.
That's right.
What I'm hearing Joel say, if it were in C, would immediately block them if the police say, no, it's under investigation, we can't release it.
The authority of the police
They can do that anyways in B.
in B.
I know, but
B is what addresses that, not C.
I understand that. I understand that. But I thought that where it says in B, pendency of an active criminal investigation involving the proceedings, I thought it was important to make sure that that included an MPD active criminal investigation.
Whatever agency is conducting but it would be
Right.
MPD in most of these cases.
But I didn't, it's important. And the reason I'm being so picky about this is that this is obviously a matter of very great importance and I want us to make sure that if we're going to enact an ordinance, we all understand exactly what its provisions are intended to do. I don't want there to be any misunderstanding amongst us about what we're passing if we pass it. That's why I'm being so picky about this.
Well, I think it just clarifies that even though we're waiting the 7-day period, the police department may continue its criminal investigation by pulling surveillance video, subpoenaing surveillance video, interviewing witnesses.
I know, Jimmy, but I didn't want to get to a point where we had an incident and the MPD was investigating it. And the stakeholders came forward and said, we want to view the body cam footage. And you guys said, well, the MPD's investigating it. And they said, well, where in this ordinance does it say that we have to wait till the MPD completes their investigation? I want to make absolutely clear that the investigations include MPD investigations.
Okay.
All right.
Insert the wording on that, maybe? Okay, go ahead.
That's what we did.
And
C.
C,
Okay,
okay.
I'm
Ben?
reading, just here, I've highlighted a couple areas from the letter we received from the district attorney regarding, excuse me, grand jury proceedings. It says, the legislature hereby finds, declares, and determines that it is essential to the fair and impartial administration of justice that all grand jury proceedings be secret and that the secrecy of such proceedings may remain inviolate. Then he goes on to say, the citizens of Mobile County exercise great power through participation in the grand jury process. Citizens have the power to indict so that my office may prosecute, and they have the power to set free the innocent or those for which the government lacks the evidence to rightly accuse. So is there any implication of the stakeholder viewing the video and then later deciding or finding that it needs to go to a grand jury?
That could happen.
And okay, so what are the implications of that?
So once it,
Does that go in contrast to the
Yeah, B and C.
protecting the integrity of the criminal process?
It almost sounds like B and C are in conflict in some
th-
ways.
they're not, and let me explain why. So once again, hats off to Mr. Linder for threading this needle. Okay, the reason that C refers to the 7-day waiting period because it's only the Grand Jury Secrecy Act that requires that you shall keep it secret. The other, they're investigatory privileges, and you may or may not, depending, you can hold back. But all discretion's taken away once the DA gets involved and start to issue subpoenas. That's why C reads the way that it does, because you commit a felony if you disclose that information once it's out. B, on the other hand, acknowledges other state law and that there is a long-standing investigatory privilege. No matter what we do or don't do in this room, that still exists. So what it requires is twofold, and B and C stand on their own and work in concert. B allows existing law to continue to operate in that, say, for instance, we're not dealing with a stakeholder who is asking in good conscience. Say, for instance, it's just somebody who says, hey, there was police brutality and this is what everybody did to me. And they say, hey, we want to see it. Well, if they're criminal charges, then MPD gets to say, well, we have a criminal investigation going on. We're bringing charges before the defense lawyer gets hands on it. However, as soon as those charges are brought, that stakeholder gets it in discovery anyway. And I think that's what we might not be saying. So our prosecutors would give it to them in general discovery anyway. They're going to get to see it if they're criminal proceedings. However, if there aren't any criminal proceedings, Mr. Linder's drafted this so that they still get to see it, one, under B, unless you give them a reason not to. But if there are no criminal proceedings, then so be it. If, as Mr. Reynolds just mentioned, however, somehow there's no criminal proceeding dealing with that person, but there is a grand jury secrecy act issue, as C references, the stakeholder still has that 7 days to be able to see it. So what you all have in front of you works, but it works in concert with existing ordinances, existing state law, privileges, and the Grand Jury Secrecy Act. Very complicated to navigate, but that's why B and C are separated. And that's, I'd imagine, why Mr. Linder set it up that way, so that you have a scenario where people can see the body cam. However, if we're dealing with that counter where there are criminal charges involved, that privilege still exists, and you still have a 7-day window before grand jury secrecy shield comes down, and that person could see it anyway. So it gives a stakeholder a number of different opportunities to see it, but also keeps the legal privilege intact for the city and for any other law enforcement entity that might be involved.
Okay, I thank you for bringing that all to clarity, but you didn't answer, and I just want to know, and you may not have the answer. In that scenario you described, where there is no problem with them viewing it within the 7-day period, and then it's discovered through Ring camera video or some other means that we may have something that needs to be in front of the grand jury, okay, that is then discovered. How does that affect the grand jury in protecting the integrity of the criminal process? What are the implications of that?
Well, limited, very limited. So I understand your question. That's a very limited scenario, but you got to remember, only the stakeholder gets to see it. Okay. And if the grand jury is going to be involved and they're going to be criminal charges, they'll get to see it subsequently anyway. The second part of that is that the DA's office could either issue subpoenas immediately or wait the 8 days. Either way, if we show it if we show the video before those subpoenas are issued, then we're still in the clear. And if
from the felony standpoint, like, I understand that we're clear from the felony
there's a
standpoint.
second part of the answer, but I think I'm answering your question. At least I hope I'm answering your question. So we're clear from this felony standpoint. However, under your scenario, if you then say, hey, afterwards we find out that grand jury secrecy act is going to apply and subpoenas did get issued, but we've already shown somebody, no harm, no foul, because they get to see it, but it's not out there in the general public. It's only the stakeholder that gets to see it, and they're going to get to see it anyway at some standpoint.
But so this is what draws my concerns tied to is that it is seen now by the stakeholder and their plaintiff's attorney.
Yes.
And now they have started this PR campaign, right, to direct a narrative one way or the other. Does that not go against protecting the integrity of the criminal process in regards to the grand jury process?
It could, but that's a very small likelihood, because more than likely what's going to happen is MPD has already made a decision either to release or not release under the privilege. And if we're dealing with, this 7-day process, the DA's office is probably going to be involved. If they're on the scene of an incident, they're going to be involved. They can decide whether or not they want to push out subpoenas immediately. So that's going to be under their discretion. And if they do, then that 7-day window is gone. Okay. Now, if they do it afterwards and you got a plaintiff's lawyer out there jumping up and down, well, that's the civil component, and the criminal component is a whole nother deal. That's a whole nother deal. And so once the Secrecy Act comes down, it applies to everybody, witnesses and all. So you might want to be a plaintiff's lawyer out there talking about, or any lawyer for that matter, talking about what's going on. But once that Grand Jury Secrecy Act window comes down, it applies to everybody involved who those subpoenas have been issued to.
But all of that is avoidable, that scenario that we just worked through. As Councilman Dave suggested, that maybe it's a good idea as a matter of public policy to set aside a period of time for those decisions to be made by the district attorney's office.
Yeah, we can't do that. I mean, we don't get to decide when they make.
Before it's released is my point. Before the body cam footage is released or shown to any stakeholder, that there is a period of time for consideration to be given by
Oh, I get your
those
point.
interested parties. We certainly have the ability to do that.
I get that.
I think
yes.
that's what you suggested earlier. I mean,
So you're saying if you want to do it immediately? If
yeah.
you- say, for instance, you want to bring.
So if say in hour one, the stakeholder makes a request, there's no criminal investigation going on at this point. The facts are coming in, slowly in this particular case. Does the DA, the stakeholder, get to see it, and then it's used in, whatever means, and then the DA comes in later? Now they've missed their window. It's already released.
Sure, that could happen, but one of that.
Viewed.
So, but you also have to think, and this is once again a credit to the drafting, is it's not just the DA's office that gets to say no. The law enforcement agency could always invoke the privilege and say no as well. Yes. So that's why he's put B and C in here. That's the fail safe, is that the agency in the city and MPD makes a determination that there's an investigatory privilege and it's locked.
Right, but so the time that even using the privileges in B, is that decision made immediately that there's a criminal investigation? When is that
Typically.
decision made?
Typically, going to be made within the first day or so. I mean, that's just how it works.
Yeah, but the way this is written, the 7-day waiting period, the 7-day window, call it, would not apply if there was an active criminal investigation.
Understood. But let's say there's not. It hasn't been declared that there is an active criminal investigation.
Well, I would think if there was an incident, I mean, I can't answer for the public safety director, but I would think if there were an incident that if there were an incident, then the police department, the investigation begins immediately on the occurrence of the incident.
Right.
The investigation begins immediately upon the occurrence of the incident, right? And not, you don't wait 2 days to decide whether you're going to investigate. The investigation occurs immediately upon the occurrence of the incident and goes on. And all we're saying here is that once the investigation is complete, now check me on this, Mr. Linder. Let's say an incident occurs and the police department looks at the incident and determines after a period of 24 hours that there's no reason for further investigation by the police department or anybody else. And so they would, under this, they would go ahead and let them see it, right? That's right. Does that kind of answer your
I
question?
understand that.
Before I get to Michael, following up on that, I guess we go back to the same scenario. If the police department is investigating, and they are investigating, but have not made any sort of announcement or public statement about an investigation is underway, and a stakeholder comes in prior to the police department making that statement, even if it's first hour, and the stakeholder requests to see the footage, and you haven't made that determination yet, would not the stakeholders' request trump what you are
Because they're
doing?
investigating.
I mean, because you
No.
are investigating, that means it is under investigation, whether you say anything or not?
We could, right? So that you could, but you're going to know to Joe Davis' point, all right? We're going to know within the first few hours
The
whether or not
investigation
there's.
begins at the minute the incident occurs.
So as long as it's under investigation, it is under investigation.
That's right.
Right.
Right. We exactly. We just have to tell them that, and we'll know whether or not we're going to bring criminal charges. I mean, we'll make that determination. That is something that we look at. So anytime we get these requests, you got to remember we get these requests all the time from defense lawyers and turn these things over. That is not new for us. Or we get subpoenas for them on a regular basis, and we still have to give the privileged response. So that scenario is not new to the city or MPD. What we're just doing is making sure we work in concert with existing laws and existing policies so that we're able to go forward operationally.
Okay. Well, like Joel had mentioned, I think whatever we approve, whatever we get to that we're going to vote on needs to be very clear so that we all understand it and that the public understands what this means.
And the police department.
And the police department, obviously, yes. So we just need to make sure of that. Corey?
Thank you, Madam Vice President. I know that we also had to make sure that we stay and follow the state guidelines as well. With the state laws, did it require us not to be able to show or view the stakeholders have the opportunity to view the footage if it was a criminal investigation going on? So if the state legislature, the laws was changed, then the ordinance could potentially change. Sure. Thank you.
CJ?
And I'm just proud that we are glad that we got this far and everything, and pretty much we're all on one accord. I appreciate everybody.
Are we all on one accord?
I just wanted to clarify with Councilmember Dave, so I think maybe we can address his concern here. Perhaps put the statement about pendency of an active criminal investigation, including one involving the Mobile Police Department, into subsection B, II, or 2. We clarified in there pendency of an active criminal investigation including one involving the city there. And then honestly, I sometimes am guilty of an excess of verbiage. So I think honestly, if we do that, we can perhaps cut everything off after the first sentence of subsection C. All of that is more or less explanatory. And if we put
You mean after,
Grand
you're just
jury
going to
proceedings?
eliminate the last sentence in
Correct.
subsection 3.
starting with this waiting period is expressly, that's the last two sentences, because really that's further explanation. And especially if we clarify subsection B a little bit, I don't know that we need it. And that may make subsection C a bit clearer that this is meant to address situations where self-reporting to the DA is at issue and therefore us triggering grand jury secrecy.
That's fine with me.
So you're saying cut it off after it says grand jury proceedings?
I'm sorry, say again?
The end of the sentence would be grand
Proceedings.
jury proceedings.
C would end with grand jury proceedings. And I think,
Off there.
yeah, and then we just insert into BII, pendency of an active criminal investigation, including one involving Mobile Police Department involving the recordings, or something close to that effect.
Question.
William?
Ricardo, does this change anything in the structure of the amendment to section 46? Does this change it? Is that a reiterating sentence that we're adding to subsection B? No.
It definitely changes it. I mean,
How so? Does that take away the ability again of the family with the MPD having the ability to say no right away?
no, that doesn't.
Or stakeholder, I mean to say.
No, it doesn't change anything that
Doesn't already exist. And so the council, whether you all implement this or not, that privilege still exists. Yeah,
for the
that's-
request of the footage,
Yes.
to review the footage.
Yes. That's
So the 7 days would still remain as is, and the section B would remain as is. But does it give any additional strength to MPD beyond section B already?
no. These are the reason that I think Mr. Linder included this, because these privileges already exist above and beyond this ordinance. They exist whether we change this ordinance or not. So it all it's doing is acknowledging what the existing law is, so that everybody clearly understands that. I think that's probably a really good thing, because then people would sometimes ignore it, and we can't ignore state law.
Joe?
I think, correct me if I'm wrong, but I think what we do by this ordinance is we confirm the right of the stakeholders to view the body cam footage within the first 7 days if there is no ongoing criminal investigation.
That is accurate, and also assuming the DA has not occupied the field preemptively.
Right. So which is unclear at this point. That privilege is unclear at this point.
That is
So
correct.
that's what we're doing with this.
Okay, I've got a question. It goes to this self-reporting issue. Does this prohibit, say, an officer involved use of force when that happens? Does that prevent, say, Public Safety Director Lasky from picking up the phone on the scene or otherwise and calling the district attorney and saying, District Attorney, just want to make you aware, we've got a use of force issue that you may have interest in? Does this prohibit that from happening?
No, it wouldn't.
Okay, this says there shall be a 7-day waiting period between any use of force incident involving law enforcement recordings and any self-reporting by the city of Mobile of same to the Mobile County District Attorney for use in grand jury proceedings. So let's see, bear with me. What is self-reporting? Is that a form? Is that a federal form that you fill out?
No.
I mean, then what is self-reporting?
So for us, it
Is
is
it a
when,
telephone call?
no, it's when you turn the information over to them. Okay. So that's when it starts. When one of two things, either they issue subpoenas because of you talking to them, but the self-reporting is when we give them the actual information, whether it's the recordings or the file or anything. That's when it triggers, or them issuing subpoenas. That's when the grand jury secrecy window comes down.
As a practical matter, if the incident occurred, and remember, the MPD investigation begins the minute the incident occurs. So the incident occurs, the MPD investigation begins, which tolls this 7-day thing, and then they call the district attorney's office and get the district. The only reason they call the district attorney's office is if they felt there was something untoward about what had occurred.
That's what I'm saying. This prohibits.
I know, but it's a practical matter. Yes.
Madam Chair,
Josh?
question. Tell me, I have this in my mind somewhere that I don't know where I got it from. Both the self-reporting to the Department of Justice, that's a voluntary thing that the administration has done as a procedure, correct?
That's right.
And then also the DA side of the house, though, as far as reporting to the DA or inviting the DA in when there is an officer involved incident, that's mandatory, correct?
Well, no. We
Okay, that's a voluntary thing too.
It's self-imposed. Those are specific policy issues brought in by this administration as a matter for training.
Yeah. So basically, what we're doing here in section B is we got a checklist. The request comes in. Is the first one done? Is the second one done? Is the third one done? and then yes, no, yeah. That's what triggers the clock to start for the 7 days. And then after that point, after the 7 days, it will be up to your policies and your procedures on the admin side of the house of whether or not you're going to report that to your Department of Justice and also the district attorney.
That's right.
Okay.
That's correct.
I think.
I think actually I'm looking at C again. I think Councilman Reynolds brings up a very good point, and that self-reporting is a little ambiguous because we do self-report these incidents. And this happened a long time ago when everybody wanted transparency. So we chose to self-report not only to the DA, but to the DOJ as well. But it might, Michael, if you look at it, maybe instead of self-reporting, submitting the recording to the DA. Maybe, yeah, because once we submit it, it's going to get protected. The shield comes down at that point, or once the subpoenas. And I think that might make it a little more clear that we can still call him and say, hey, we got an officer involved shooting. But the submission of the recordings won't occur for 7 days unless otherwise instructed by the DA. That's right. That's right.
Rob, did you have something?
I've been on the other side of this with the federal government. I'm suing the DA. Just because they don't tell us it happened, we know it's happened. And if as the FBI, if they determine they want to look into it, they're not going to wait for a call to say or self-report. They're going to send people out. And I pretty much assume the DA is going to do the same thing. And I'm pretty much assuming that the U.S. Attorney's Office is going to say, just because you don't self-report or I don't give the SAC a call, say, hey, we had officer involved shooting, doesn't mean he doesn't know, and doesn't mean he doesn't understand. It doesn't mean he's not going to react on his own, given the information.
Okay. All right. So where are we on this? I think we've got some word changing, few deletions here and there. You been keeping up with everything? Are there any other questions on this before we head on to the next item?
Yeah. I asked that we have that third party section added to this too for review. I don't see it in this. I do know that the administration has now taken on a third party to review body cams. So I think it would be prudent that we add that language, or if the 79 language protects us or still allows for the third party, then we need to answer that now too, being that we've gone down that road in-house ourselves with a third party.
I'd like to ask that we go ahead, since we've reached a consensus on this, that we go ahead and deal with this and deal with what Mr. Carroll's suggesting as a separate matter.
It was part of my request last week. And being that the administration is already going down that road, I think that I'm due to have my question answered, or I'm due to have the structure of the ordinance reflect the policy procedures that we now have in place without structure. So my question is that being that the administration again has already taken us down that road with the third party, does the 79 ordinance hold us to that, or is that what we're acting under, or do we need some language to so it already allows it, so it remains in place, and it would be up to you guys to decide if we're going to do that, or will the council be able to ask, hey guys, I think that we need to have a third party in here?
Council could request, the 79 ordinance basically leaves it within the purview of the administration to share what was called, I believe it was non-conviction data, which would be anything in the file that isn't strict vital statistics on a conviction. But the 79 ordinance had a couple of methods by which the administration can make an agreement with outside parties or organizations for review of non-conviction data. Yeah.
Well, the reason why I'm asking is because as stated last week, I believe, is that the 79 ordinance was enacted before Zogby. Do we need to amend that to make sure that we're running parallel with Zogby?
Not in its current form. It's not that particular part that Mr. not contrary to state law.
It's not contrary.
No, because it leaves the ability up to the administration. So it's not a directive or a shall. It's the ability to do so, which we have anyway.
Okay, all right, anybody else? All right, I know Mr. Daves is running up against a timeline here, so let's, Michael, you've got your instructions, I think. And if you can come back with a clean ordinance amendment for us. Is this on the agenda for next week?
The 12th, I think.
The 12th? Okay. Because we'll need to see the final version prior to Thursday, if that would be,
I think the changes are simple enough. I can circulate a draft to everybody by today.
oh, that'd be great.
Well,
Okay.
when you say circulate the draft, you're talking about the entire draft, all sections, correct?
Yes,
Included.
of this ordinance. I don't really have,
No, just this ordinance.
yeah, just the body cam ordinance right now.
Okay, yeah.
And maybe the other one, depending on how it goes.
Well, let's not count our
But
chickens.
for some reason, I still think they're all under one section. So we're just amending one section of law, right?
But this is the only one that we have gotten this far on.
These ordinances actually create two new subsections under the city police code. So it would be subsections 10 and 11, I believe, respectively. But they're entirely new provisions the way they're written.
Let's see how far we get on this one then.
I think it's going to be a lot easier to deal with this if we deal with it one piece at a time.
Well, he just
So-
said we're adding two subsections to the existing ordinance. So
Well, if we have to next week, we can vote on the one amendment and then come back on the other one. If we don't get far enough along today on,
Madam
on
Chairman, I think
Corey's.
if you push us along, we'll get there.
Well, I'm trying to. All right. I know Corey, this is yours. Why don't you start off?
Yeah, thank you, Madam Vice President. Honestly, I don't think this is going to be long. I believe that I already spoke with the administration. I talked to all my colleagues. Michael Linder, he can state, the administration can state, and we can move forward. Administration, I want to.
Yeah, I've been talking to Councilman Penn as well as other councilors about this. I stated earlier when I originally heard that there was going to be this ordinance, I called Councilman Penn last week in opposition to the ordinance. But then when I saw the ordinance, it wasn't anything like had been explained to me. And so what I found was that the ordinance tracks the current policy within the police department very closely. There's a few edits that I brought up. The police department actually includes all warrants, arrest warrants and search warrants. And so we wanted to add that in there, that pre-dawn or no knocks, whether it's an arrest warrant or a search warrant, would be included in the ordinance. And so we took out the word search is what we did. The exceptions, I was talking to Corey Penn, is how that approval process looks when there's a request for a no knock or pre-dawn warrant. It's made by a lieutenant after conferring with a sergeant. That request then goes to a captain in the police department, which then goes to a major within the police department for approval, which then goes to the assistant chief for approval before it gets to the police chief. And the police chief ultimately can stop it right there and choose an alternative. If the police chief wants to proceed with a no-knock or a pre-dawn warrant, the way we discussed this a little while ago, and any of those other command level officers is in disagreement for officer safety reasons, then it has to be pushed above to the public safety director at that point to settle the agreement, whether there's truly an officer safety issue or is there a safe alternative. If the language that's in the police department signed by Chief Prine, and he's here, and he's totally in agreement with this, we can proceed. Chief, did you want to make any comments?
Thank you. I would just simply say that there's a 5-layer process to this, Mr. Penn, and that is that when it's pushed up to the lieutenant, it will be vetted through that entire chain of command. What we're doing now currently as we speak is creating a workflow that allows that process. So there'll be a documented workflow that also shows that vetting and that approval process as well. So I think it is, nothing is foolproof, but we do think it's a start in the right direction that accommodates what everybody's looking for.
Corey, did you have anything else? All right, CJ.
Chief, you had mentioned that if it reached to the police chief and there are lesser officers still scared of is the safety, what we don't have a public safety director? Because from my understanding, before y'all administration, I don't think there was, did y'all really have a public safety director?
We have off
Mike
and
Dow
on,
did.
but-
That's what I'm saying. What if one is not in place, then what?
The, with absent a public safety director, it's been the protocol of all the administrations, including Sam Jones, that the chief of staff then acts as the public safety director. The same would go if, the public safety director is out on a cruise and the chief needs, he's got a dissenting opinion, and because of officer safety issues, it would still flow to the chief of staff or the city attorney in the absence of the chief of staff. So the safeguards are all there for third-party approval. I do want to make a comment because there's been some comments and I heard of, which has caused me some alarm, that Corey Penn was trying to ban these things. This does not ban them. I just wanted to be clear publicly, but it allows for it for officer safety purposes. So this actually has a very good balance between officer safety and safety of the community, which is that balance that we're trying to strike. It's what the police department wants to see, and it's what Councilman Penn wants to see. So this is not a ban. It's just very restrictive in its nature. It makes it more the exemption to the fact.
Okay. Josh?
Quick question, I guess, for if taking what Councilman Penn proposes here, and then obviously you said you felt comfortable with the changes in the memorandum. So pulling that over here, it would say, it has to be approved by, based on the memo, the chief of police, or in his absence, the assistant chief of police. What if it comes down to that dissenting point where it does have to go to the public safety director? Would, as his boss, the chief of police would, or the assistant chief of police would then approve it based on his recommendation as his boss, as his director at that point, I guess. Does the language need to add, or in the absence of chief of police and a dissenting opinion, public safety director?
Well, I think the proposed action was that if there's no dissension amongst that 5-layer approval process, and the chief agrees that in order to proceed with the safety of the officers in mind, then he owns it at that point.
Okay.
But if any of those other command level officers dissent because of officer safety reasons, that this would endanger lives of officers, that's when it flows up. Now, that language is not contained in the internal memo. It's language, I think, that similar to what Councilman Penn proposed, but it's really kind of like, if this condition exists, if everybody's in approval, there's no need for it. If there's dissension among the ranks, then it goes up for final approval. I do understand that the chief can nix it right there, but if the chief says no, it never leaves the department.
Okay. All right. Joel, Corey?
The ordinance that's before us stipulates that in both cases, no knock warrants and the pre-dawn raids, that both the chief of police and the director of public safety have to approve of the same in writing and certifies their probable cause as certain circumstances exist. Right?
That's the draft ordinance. That's correct. It's
Is this the one, Corey? This is the one that you're,
Where are these amendments?
yeah, and I do want to make it, and I wanted to make it clear that I can't really offer an amendment. This is actually going to have to be Corey to offer that amendment.
And that's what I was saying. I mean, do you feel comfortable with the memorandum? Or what's your take on that?
So going forward, of course, one of the reasons why I wanted to put this in place, we have seen certain situations that took place in our city. And I believe with these pre-done raids, putting exceptions in place, this will help. And no knock will help. And of course, I told this wasn't attack against the Mobile Police Department, but I believe that having these things in place would definitely have help. And of course, I'm okay with these decisions, with the amendments going forward. I believe this will help move forward the city and bring some form of trust and transparency in our city. So with the support of the council, I would like to move forward.
Anybody else? Okay, Ben?
Yeah, just a question, I guess is for the chief. I would imagine there are, huh?
Police or?
Staff, the chief
Oh.
of police.
Chief of Police. The workflow you're talking about within the police department, I'm sure there are other things that must move sort of through the chain of command all the way to your desk. Does this slow you down or, make things, I guess, more challenging?
Anytime we change policy to the fact where, the chief is going to have to be directly involved in those aspects, it will. But in this particular case, not really, because most of the vast majority of those search warrants are going to be made or obtained long before, probably 2 or 3 days before the need to execute. There will be those times where, especially when you think about a homicide suspect being apprehended, where you develop a target, really quick and usually within a few days. But it's really not going to be unlike contacting a judge. I mean, there may be times if the window is from midnight to sunrise in the morning, there may be times where an investigator that's out working midnight on a homicide case will have to wake me up to get that approval. But at the end of the day, we understand the sensitivity, and we also understand the willingness to cooperate as well. We want transparency as well. And so at the end of the day, it's like anything else, it will become the norm at some point.
And I guess it's important to say also that this is a tactic. This is really only on these two tactics, pre-dawn and no-knock. But prior to any search warrant being issued, probable cause is found by a judge. Is that right?
Yes, sir.
Okay. So it's not like the police department's just making this decision on their own. They're also have an elected judge, making these decisions. Would it always be a judge that decides this?
Yes, for search warrants,
For
yes.
search warrants. Okay. Thank you, Chief.
For a search warrant. An arrest warrant is going to be made through the magistrate. Yeah.
Thank you, Chief.
Yes, sir.
Thank you, Madam Vice President. I want to thank my colleagues. I want to thank the administration. Of course, this process has been very, challenging. I have received emails that people believe that I was attacking the police department, and I wasn't. I'm a major supporter of our officers. I receive emails, not all, some good, a lot of good, but I received some bad ones as well. Said that I'm a cancer to the city. And, because of me wanting to just create a better community, a better city. And that wasn't my desire to create anger. I want to build my community. I want my community to become stronger, my city to become stronger, and work together to do this. And today we showed that. We show that we can do that together. So I want to thank the administration. I want to thank Pastor Lou, who reached out months ago to try to make that happen. I want to thank Councilman Richardson, who reached out a month ago to start working on this. I want to thank our attorney, Mr. Linder. Thank you so much for helping create this ordinance. And I want to thank my colleague. Hopefully y'all will support on next week to pass this. We have to move our city forward, and we can do this together. We are stronger together. Thank you, Madam Vice President.
William?
In the interest of foregone traditions, when we have, I think, unanimous support without voting, Corey, please add me as a sponsor. CJ, please add me as a sponsor. And if the clerk would do that before the next meeting, then please include me.
Ben?
Approximately how many pre-dawn How many times do we use this pre-dawn tactic per year on a warrant?
Average.
Just,
yeah.
just approximately.
Everything's under review. Some of the comments, there would probably be some more changes. But the whole process is being.
Okay.
I can tell you we handled the SWAT, but that's very normal operation.
Okay, anybody else? Okay, I think this one, unless I'm mistaken, is good to go on the,
If I might ask,
Okay.
Councilmember Penn and Carol as sponsor, do you want me to track the directive as we've gotten it from the administration here?
Yeah.
Taking it to chief of police and
Yeah.
and so on?
Yeah. yeah, and if you'll go ahead and just put the whole thing together and send it to us, yeah. Everybody good with that?
Two separate items on the agenda.
Yes, two subsections.
Well, we're amending the same, okay,
Well, it's
Okay.
adding two subsections.
all right,
So-
that's fine,
so
just keep it separate, that's fine. All right, anybody else?
Any other sponsors?
We can make it unanimous, that's fine,
Unanimous?
I'm game.
yeah,
So we have a unanimous sponsor.
that's fine, yeah. All right, any other business before the committee? All right, do we have a motion to adjourn?
Motion.
We are adjourned.
Yes.